Okay, good morning, everyone. I'm Yuval Shany. Let me congratulate you belatedly on arriving to this very interesting conference. Unfortunately, I couldn't attend large parts of the sessions yesterday, but what I've heard was very interesting and provocative. And I'm sure that we're going to have a very interesting day of discussions today as well. We're starting with a very masculine panel. This morning for some reason or the other. If yesterday I think was more about the conceptual issues concerning to targeting and what would constitute a military objective, and I think a theme that came across very strongly, at least in the parts that I attended, was that it's very important to contextualize these issues and decision. So this morning we're starting to contextualize. And the first framework for contextualization is whether the character, the nature of the conflict, has bearings on what we deem to constitute a military objective. And we are going to discuss this morning two basic themes, which are overlapping and interrelated. One is the asymmetric conflict paradigm, which raises a number of challenges concerning how does one designate military objectives. And the other one is the non-international armed conflict, which arguably raises its own host of challenges, although as we will see this morning, the two are somewhat intertwined. So I'm not going to speak anymore, and I'm going to deliver the floor to our four presenters, who are actually five. Four presentations delivered by five presenters. Our first speaker is a repeat visitor to our conferences, Dr. Eitan Barak from the International Relations Department here at the university. Eitan is really the country's top expert on the field of arms control and disarmament and the law of weaponry. He has published extensively on international security regimes and Israel's defense policy. And with respect to the law of weaponry, he has published specifically on two types of weapons. One is cluster munitions, and secondly, he has written a book on flechette weapons. And today, Eitan is going to discuss the issue of military objectives in asymmetric conflict, using as a case study the Worrisome case of the Second Lebanon War. So without further ado, Eitan, the floor is yours.
What attracted my eyes in the call for proposal was in the second page, a section which referred to the PGM. And it refers that promise from the IHL perspective. And I would like to show you that in the at least in the mid and near in the mid future, it is a false promise. Okay, let's see if it works. So the call proposal, then and then there's weather and weather and weather, and all these things, as we will see, will not occur. Okay, this is of course PGM, highly acute surface-to-surface missile, which was used in the Second Lebanon War. And we will see what's happening in that war regarding munition, and some interesting thing happened. So this, of course, is the underlying assumption. PGM could and should reduce the collateral damage in war. However, the Second Lebanon War posed question mark on that assumption. What's happened in that war when we come to firepower? Ground forces, a huge number of shells were used. As you can see, more than 170,000, including more than 1,800 MLRS rockets, as you can see in the picture. To give you some, to impress you, compare with the number of shells in the 1967 war, in which we fight free a regular army. Here there's missing one. It's 145 shell in the 1973 war, in which we fight two regular army with the help of Iraqi forces and even Saudi forces. In Litani operation, in the 1978 Litani operation, in which Israel took control over the same area, Israel has used only 7,000 shell. And in the first Lebanon war, in which Israel fight even against the Syrian, it was 81. So it's a huge number which was used. Air Force, the Israel Air Force has carried more than 1,000 sorties. It's, in fact, it's 350 per day. It's amazing. It's comparing to other war. As you can see, it's the same. It's even more sortie than in the 1973 war. It is, of course, the Popeye. It's air-to-surface missile. And indeed, the Winograd Commission, which was established after the war to investigate it, there is a section which deals with breaches of international law, and it sums up that the quantity of munition was very high when compared to former war. The main problem is that within the entire stock of munition used, there was area weapons, in this case cluster munition, which also have post-conflict effect, something which Ruby will discuss probably. The ground forces use, as I said, more than 1,800 rockets. The problem is that each rocket contains more than 600 bomblets, so you can see the huge number of bomblets which was used. It's enough that there is few percentage of darts, and you can imagine the post-conflict effect. And of course, beside the rockets, more than 8,000 shell were used, from which part of them was Israeli made. Israeli made contains 63 versus the 88 bomblet in the American shell. So again, there is a high rate of that, especially from the American shell. As to the Air Force, the Israel Air Force clean his depot and use the Vietnam era CBU-58. It's a very old weapon. Some of them were found with expiration date September 1973. As you can see, bombs that were found. In fact, it shouldn't reach the ground. It should disappear. This is a total failure of the bomb. However, what about the use of PGM? Interestingly, there was also massive use of PGM. Ground forces, only after the war it was revealed that the ground forces used 600 deadly high-IQ TV-guided missile. This missile was exposed only on 2011. It was highly classified, it entered into the Israeli IDF in the mid-80s and was classified until 2011, and they used a huge amount, mainly because there is a new version, so good opportunity to clean the depot, but in any case, it's a huge number. And Air Force, even the Air Force, and we have a very acute data, 36% of the munition were various PGM, like here, the Popeye missile. And this compared to 1% in the 1973 war and 3.4% in the 1982 First Lebanon War. So, as you can see, it's a very interesting case that you have used a lot of PGM, but in the overall, there is no effect. And then there's a question, could the massive use of PGM could have served as a substitute to the use of area weapons, because area weapons is the most problematic issue from the IHL perspective, especially cluster munition, which, unlike other area weapons like flechette, they have post-conflict effect. So what was the purpose of using so such a huge amount of area weapons. So first, there were three purposes. The first one was preventing rocket fire on Israel by targeting the rocket launcher. What happened is that Hezbollah, the Hezbollah organization, launched rockets all the entire 34 days of the war. Even in the last day, they fire more than 200 rockets. And since Israel avoid sending troops until the very last stage of the war, they want to prevent the rocket disturb the entire life in northern Israel, and then they try to fire on the places from which the rocket will fire, but it, in retrospective, it was to no avail. Second purpose was that once they found out that they cannot prevent the firing, they cannot target the launcher, so they said, we will disturb the firing by simply fire cluster munition towards what the Israeli called the nature reserve, the places from which rockets were fired, and then the Hezbollah personnel will see that there is all the time there is bombarded, and they will avoid coming to that area and launching the rockets, which were of course prepared before the war. So they simply fire a barrage of ammunition, but to no avail. And the last purpose was artillery support for ground forces. Here again, we will see what's happened. So this was the three purpose for which Israel has used cluster munition. The use of PGM as substitute, this is the launcher of the missile, the Tammuz missile. First, the use negative for the first purpose because two reasons. First, high number of actual target. There was more than 6,000 target. So no army could afford such a high number of PGM. A shell cost some $200 to $300. PGM could reach $200,000. So and in any case, it's beyond the size of the IDF available arsenal. Second thing, when it's come to either laser, and then there should be illuminated by designated laser, or even a TV missile, somebody should observe it and should direct the missile. So it has not been done. The only case it was been done is that a unit has taken control over a ridge next to, in the vicinity of Tzur, and from that ridge she could direct a missile, and that was part of the 600 missiles that were fired, and that proved highly efficient. But in order to continue this way, you need to send troops to all the area in which there was nature reserve, and Israel prefer to avoid it, and then you can't use this missile. As for the second purpose, again, the required amount of PGM excluded their use, and in case there is no point because there is no target, you just want to create a situation in which nobody enter the nature reserve. And of course, again, no full coverage was achieved, so you cannot simply launch the missile. And here, of course, the non-use of PGM has devastation effect because part of this firing, in many cases, the rocket will launch from inside the village. So a military objective inside civilian area, and while the village were empty because the resident fled, they fled because Israel shelled the village. So what's happened is that once they fire a cluster munition, once the war was over, people come back to their houses, and then they found cluster munition. And here there is an interesting section in the Winograd Commission, which is very related to will be a presentation in which the MAG, the Israeli MAG, was asked if it's legal to fire all the cluster munition to villages, and he said it was legal because at the time of the firing there were no civilian, and there is no doubt. Even Human Rights Watch, for example, in his report, do not blame that civilians were killed during the fight because people are taking cover in the shelter, and the cluster munition does not penetrate to the shelter. And then the Winograd Commission said that in her view, military commander should also take into consideration the post-conflict effect, although he is in the middle of the battle and so on, and this is a very important contribution to IGL. But we continue to the main subject, and the last purpose, meaning as an assistant to ground forces. Here again, it was as an assistant and not as the main weapons to be used. The main was, of course, conventional, regular munition. So even here, the PGM failed to meet the expectation. Here you can see this is a rare picture which was released by the IDF spokesman. It's in the Gaza Strip. It's a missile that approached someone, jihadist. This is his final moment. When he came back to take the launcher, he heard the noise and he looked on the sky and he see the missile is coming. You can imagine his last word. Oh shit, probably. And so it shows you that the accuracy but when it's come to war, there's a problem. So primary insight is that PGM represent a false promise from an IL perspective. Despite the massive use in this circumstance, they failed to prevent the massive use of regular ammunition, let alone area weapons that are inherently prone to inflict. There is no substitute in the near future to this cheap and regular ammunition. So this is the initial. Is clearly worrisome. There's not a lot to hope from PGM when it's come to war, as differ from a sole operation or targeted assassination, something like that. Many thanks.
Okay, thank you, Eitan. We now move on. We start with our series of Noams. The first Noam who will speak is Colonel Noam Neuman, who is the head of the International Law Department in the Military Advocate General Corps of the IDF. Colonel Neuman has served for the IDF for many years, since the almost 20 years ago. You look much younger now than that. And he has served for almost a decade as a legal advisor in Gaza, and subsequently as the head of the Security and Operational Branch at the International Law Department, and since 2009 he's been the head of the department. And he is specialized in a number of operational law, conflict-related, and occupation law-related matters. Colonel Neuman is a graduate of the Israel National Defense College and the IDF Command and Staff College. He has a law degree from Bar-Ilan University, and then he had 3 master degrees, one in law from Bar-Ilan, one in philosophy from Bar-Ilan, one in law from Charlottesville, Virginia, from the JAG Legal Center, and one in political science from Haifa University. So it's really a very interesting combination. Colonel Neuman is going to discuss the spatial delimitation of military objectives in asymmetric warfare.
Okay, thanks for the kind introduction, and thank you for inviting me to speak at this conference. I will start my presentation in several minutes, but first I want to say something about what what Dr. Barak just said. I don't have time to go into the details that he talked about, but I wish I had more time in order to respond to the aspects that he talked, because they are very, very important and relevant. But I just wanted to say two points. The first one, I think it's problematic to learn and to conclude from numbers to legality. If you're talking about numbers, how many shells, how many sorties per day, how many cluster munitions was used, this is an important thing, we could discuss it, but it says nothing about legality. We might use a lot of amount of weapons and still everything was legal, and the opposite. And just to say, we talked about how many sorties per day. We had an operation last year, the Pillar of Defense operation. As far as I know, in these operations, we had more sorties per day than in the Second Lebanon War. So what? So what does it mean? It means that it was less lawful or not? And I think these are really, really crucial issues. I think we should discuss the questions about open to target an open area, to use cluster munitions, about shells, etc. But my presentations will be focused about the military. What is the military objective? What is the special delimitation? And I think the Second Lebanon War is a good example to a conflict that law-abiding armies have in relation to a case in which you fight against non-state actors like Hezbollah. And it raises several dilemmas that I would like to raise. The second point is that it's not a theoretical question for me. I was in the Second Lebanon War. I was the head of the Operational and Security Branch in the International Department. I gave legal advice to general staff level, and I advised also the legal advisor for the Northern Command. And I can assure that the rules that were applied about military objective were the same rules that we talked about. Article 52, nature, location, purpose, use, effective contribution to military action, offer definite military advantage. These were the rules. These were the rules were applied, and we talked about targeting. This is what we did. So we can argue about this or that, but in reality, I can assure that this rule were applied. But my presentation will be about, especially when we are talking about these kind of cases, when the enemy is embedded within the civilian infrastructure. We use civilian houses for military purposes. So what is the special delimitations of the military objective? What does it mean? What is exactly the military objective? And I'll go through several examples. These are theoretical ones, but they derive out of experiences that I have in relation to this kind of questions. And I think that it will just give you some ideas about the dilemmas that we have to share. And I don't have real good answers to all of them. I have just more questions, and I think there are more considerations that should be thought about when we think about this kind of operation and this kind of cases. The first one is about high-rise building. There is launchers on the roof. I think everyone will agree that the launchers are military objective. We can attack them. The question is about the building. Is the building a military objective? Some might argue it is not. It's collateral damage. Only the launchers are the objective. I think this is problematic answer. The house is being used in order to launch the rockets. It's not coincidence that they choose this house. It's the high rise, and it's much more. They give much more sense to use this kind of houses. And we might even add that the roof is specially adapted for the launcher. So in that case, everyone will agree that it is a military objective. The question is, what is it? Is it only the roof that is being used, or is it all the building? And it's relevant because if it's only the roof, we might ask the army to try to attack only the roof, and it's not hard to do this. There are some munitions that you can put a light one and will destroy the roof, and the house will not be destroyed. And if the house is destroyed, we'll ask them to calculate the rest of the house in the proportionality analysis. So the question is, what here is the military objective? Is it the roof or the old building? The second example is a mosque. There is a minaret in the mosque. We have ground forces put on the ground. There is a sniping position within the minaret. It's very effective. The snipers killed several of our soldiers. There is a need to destroy it. They do it as fast as quick as possible. And the question is, what is the military objective here? Is it only the minaret or the whole mosque, the whole building? Now, there might be cases in which it's easy to target only the minaret. If there is a attack helicopter, I think the weapons that he has can target only the minaret. But there might be cases that it's almost possible. If you have only ground forces, they have tanks, they have shells. There might be cases in which it would be very, very hard to target the minaret, but it would be much easier to target the object, the mosque itself. And the question is, what is the object here? Is it only the minaret or maybe the whole mosque? And the third example will be about high-rise building. We have good intelligence. We know that in the second floor of the house is being used for military purposes. We know exactly where they are, and we need to target it. And the same question arises. Should we try to target only the second floor, or can we target the whole building? So there might be cases in which it's possible to target only the second floor, although in most of the cases it will be almost impossible. There was one famous case in Gaza that we had information that in the third floor there are some high senior terrorist leaders. We want to kill them because it just was in the process of planning an attack, a terrorist attack. We were not sure exactly if they are in the third floor or other floors, but the intelligence says probably they are in the third floor. There were civilians in the area. And eventually, it was after a Shahada case, and eventually the IDF decided to attack the Air Force, attack only the third floor, and eventually it appeared to be that they were in the second floor and they escaped. So that was the case. Sometimes it's possible to have this kind of attacks, but sometimes it is not possible. And I'm talking about, in general, what will be the military objective in these cases. And in all the cases, I assume there are no civilians. If there are civilians, of course, they should be taken into account in the proportionality analysis. The question is about the property itself, if there are no civilians. Now, when we are looking into additional protocol 1, about its paragraphs, I think that it's really, you can say that, for example, Article 51.5a, it says, an attack is indiscriminate where it uses any method or means which treat as a single military objective a number of clearly separated and distinct military objectives located in a city, town, village, or other area. And the words clearly separated and distinct in a village or a city, town, it talks about structure, talks about houses, talks about buildings, not about floors in a building or about which one of the room. And I think it's really that the prevalent view might be that the object is the object itself. It's the house. It's not. You don't have to be more specific. In a lot of cases, it might be a good reason to do so. It might be from the. And I can tell you that in most of the cases that we had, the IDF will, if we have enough time and we have enough time to consider, enough time to plan, and we know exactly where it is, we'll prefer to locate the specific place. In a lot of time, it's because of the case of civilians. From legally speaking, I'm not sure that we can say that in this example or the other example, the answer should be that the special delimitation of the military objective is only the places that is being used. If it was the case, so for example, in the mosque case, you might say that if you have only shells, it's indiscriminate attack because you cannot attack the minaret, you can attack only the whole building. And in this case, if you say that the only military objective is the second floor, so if you will not be able to attack the second floor, you can use PGM and penetrate through all the floors until the second one and then destroy the whole buildings. So you might say that you have to calculate the whole floors until the second one, and then the attack might be disproportional. And I think it might be the case, but it gives incentive to non-state actors to use this kind of attacks, and it might be problematic from the legal sense. But moreover, if we have a case like this, that we don't know which part of the building is being used for military purposes, it might be in this case, it might be in the minaret. We just don't know. We have no idea. We know for sure that the house is being used for military purposes. We just don't know where. So if we'll adopt the interpretation, the narrower one that said only the part that is being used is the military objective and the rest are civilian one, so one might claim this is indiscriminate attack because you discriminate between the military part in the building and the other parts. And I think this conclusion is very, very problematic. I don't think this is the prevailed view. One might argue, and I heard this argument yesterday, that if you have PGM and there is a possibility to use them and you have enough time and they don't cost so much and you don't want to keep them for further attacks, because I think in most of the cases if you have limited the number of PGMs or even more accurate weapon, you might prefer to take him into other cases in which you want to spare the life of civilians and not the life of property. But even let's assume that you don't have all this. You are the US Army, you have unlimited number of PGMs, money is not considerations. Even though I think it's problematic to say that if you have all this, only the part that is being used is the military objective. It might be the case in cyber. Cyber is something else. It's not tangible objects. It's all this virtual world. It's much more complex. It might be the case. It might be. I don't know. It's something that should be considered. I'm not sure that this is the law as it is now. So this is about one military objective that we refer to. Just keep in mind that what I'm telling about, the same answer will be in relation to smaller houses. Let's assume that we have one small house, only 2 floors, where one is being used for civilian purposes, and the second is they rent it for the non-state actors, is using it as for military purposes. And in that case, it's the same. Does the house military objective or only the second floor? And the same question will be if you don't know exactly where in the house. I think to say if you don't know, you are not allowed to attack the house and it will be indiscriminate is something that is not, is very, very hard to come into a conclusion. The really hard one are these cases. A case when you have, for example, 2 houses, they are near each other, you know for sure one of them is being used for military purposes. And there's it's 100%, but you don't know which one of them. There might be a great military need to attack it because one of them, the one that is being used for military purposes, is very, very dangerous. They plan something that we just need to prevent. And the question is it legal to attack both buildings? Because you know for sure that one is a military objective, but you don't know whom. And I've asked these questions about several scholars and practitioners, and I've got 3 different answers. One is, this is speculative targets, 50% is not enough, you're not allowed to attack, and you have to ask intelligence, give me more information. If you don't have, I don't know how much information, maybe 60, 70%, 80%, 50% is surely not enough, there is a case of a doubt, and this is reasonable doubt, and then you cannot go for it. The second one is it depends on the military need. If the military need is really huge, is really high, you might be able to attack. You have to view it from the consideration of a reasonable commander. A reasonable commander that knows that in one of these 2 buildings there is Osama bin Laden or the head of the organizations that we're fighting about. If he'll know that there is 50%, he will attack them both, and maybe by this he'll end the war. If it's only a regular pilot, or maybe there are some arms there, the attack will not be reasonable to continue with the attack. And the third proposal was like the one that Pnina proposed yesterday. Let's start with the distinction, but we have to continue with the proportionality. If you know for sure that one is being used for military object and one is the proportion the collateral damage. So if no matter which one of them is military objective, the other will be reasonable, not excessive in relation to the military advantage. So look at it a rule, and then you can continue with the attack. But if the military need is not so high and the collateral damage might be more than this, so you will not be able to proceed with the attack. So this is about 2 buildings. Now let's assume we are talking about one house and a warehouse aside, and there is connection between them. The same one is own the warehouse. We have intelligence in his property. There is something. There are some weapons which might be very destructive, and we need to destroy them. We just don't know where in the property. It's in the warehouse or the house. Can we continue with the attack? Now I think there is more sense to say maybe yes, because it's the same person, the same property. It's not really distinct. Of course, it's 2 military distinct objects, but there is nexus between them. And let's assume let's go further, 2 warehouses. Now let's assume that it's great military need. I can give you one example. You know that there is a risk of tunnels from Gaza. Last month, I was in the tunnels that the Hamas dig beneath the border of Israel. It's go hundreds of meters into Israel. It's very, very complex to deal with it. If there will be a tunnel like this, and they might, I can go straight in this tunnel, and there are lines, and it's really, really huge, and it's very, very, very sophisticated tunnel. And if they will be able to use it, it might be, they might be able to initiate a terrorist attack, which is very, very dangerous to the life of the Israeli civilians. Let's assume that we have intelligence. We know this night an attack is going to be occurred. We know it will be occurred. A tunnel will be used in order to do this attack. We know for sure that the entrance to the tunnel is in one of these 2 warehouses. We know for sure there's a gut, but we don't know which one of them. If we destroy them both, then the terrorist attack will not be able to continue. We will be able to prevent it. They will not be able to go into Israel and do it. If we will not do this, so we are not sure we'll be able to prevent the attack. So what will be the answer in this case? So I can tell you the one answer that I got from one of the human rights organizations was, it's illegal. You are not, legally speaking, you are not allowed to do this. But I think that if you will do it, everyone will understand it. You will it will be okay with you. But the legal advice you should give, it's illegal. I think this is a very, very problematic answer, because it means when I said it to the army, it's illegal, but continue with it. After this, we go to the other example. Say, okay, when we have the 2 houses, why the answer should not be the same? Or when maybe we have 4 houses. Because if it's legal, we can to say it's illegal, but still you might go with it because no one will care. I think this is a problematic answer, and I'm not sure I want to go and take this position. And the last example is about compounds. In the compounds, there is a huge nexus between the objects within the compound. And we know that this is the Osama bin Laden example. We know that the terrorist organization is using the compounds for military purposes. We know that there is a wall circled the compound, and there is something that they are doing within it. We just don't know for sure. We have no accurate evidence to tell us which one of the objects in the compound is being used for what. So what does it mean? Does it mean that there is a great doubt about the military nexus, or if any one of these objects within the compound is a military objective, or maybe because it's one compound, so we can refer to it as something different. Maybe compounds like this should be regarded as one military objective, and then we'll be able to attack it. It might be the case, for example, if we're talking about fight against regular armies, we can view a military base as one military objective. We don't need to look into it and to see which one of the parts is being used for civilian one. If you know for sure that one building is being used for synagogue or for kindergarten, etc., like in the US, we will not be able to attack it. But as general, we can assume that everything is being used for military purposes. So there was a question yesterday about the continuous command function. Maybe it's the same. If you know for sure that this compound is being used for military purposes, but non-state actors and all the operatives there are militians, and you want to attack the objects and not the people, because you can always say, I want to take out the people that are there, and all the rest is collateral damage. But I think it's an easy answer. Sometimes you might want to just attack the house. You might even want to warn them because you are afraid that there will be collateral damage, etc. And the question is, which part of the compound is the military objective? So these are the example. I think that in reality, when law-abiding militaries fight non-state actors, in a lot of cases, the other side will use the enemy, the civilian infrastructure for its purposes. And sometimes it will be very, very difficult to know which part of the building is being used for military purposes. But even if you know, I'm not sure that there is a legal obligation regarding it. There might be some considerations that you have to take into account. There might be, I think it's legitimate to say there might be views that regard only the part of it as a military objective if you have the ability to do this and it's feasible, etc. I think that the question is much more complex if you are talking about separate buildings. There might be arguments for both sides, and anyone that you adopt will raise several problems, but nevertheless, we need to just decide which one is the one that should be adopted, taking into account what IHL is about and about the nature of this conflict, especially with regard to asymmetric warfare and regarding the need to just spare civilians' life and minimize the collateral damage. And I think that this issue has not been just talked about, and I think there should be more talks like this, and scholars should write more about this, because these issues are very, very crucial, and I think it's important to explore them together. Thank you.
Thank you very much, Noam. Our next speaker is Noam Zamir. Noam Zamir is a former student of mine and also a former teaching assistant of mine, so it gives me particular pleasure to welcome him here. Noam is a graduate of the Chaim Strix School of Law, the College of Management in Rishon LeZion. He's been a Wiedenfeld scholar at Oxford University and a visiting researcher at Harvard Law School, and he's currently pursuing a PhD dissertation at Cambridge under the tutelage of Professor James Crawford. Noam's work focuses on foreign interventions in civil wars from the perspective of conflict classification under IHL. And his topic today is titled Distinction Matters: Rethinking the Protection of Civilian Objects in Non-International Armed Conflicts. No.
Good morning. Well, first I would like to thank the organizers for organizing this conference and inviting me. It's an honor and pleasure to be here. My main argument today is that granting full protection to civilian objects in non-international armed conflicts, a protection that is equal to the protection that these objects enjoy in international armed conflicts, may have undesirable results in light of states' obligations to maintain law and order. Accordingly, I will argue that distinction between international armed conflicts and non-international armed conflicts matters even when it comes to the protection of civilian objects. Now, to exemplify my argument, I will talk about destruction of property in law enforcement operations. But first, let's start with treaty law. So under treaty law, briefly, it's enough to state that in international armed conflicts, all civilian objects are protected. Under Additional Protocol 1, this protection, which is also part of customary law, provides blanket prohibition on targeting anything which is not a military objective. In non-international armed conflicts, on the other hand, only limited civilian objects are protected, such as objects indispensable to the protection of the civilian population and cultural objects under Additional Protocol 2. Interestingly, the ICRC proposed to grant full protection to all civilian objects in non-international armed conflicts as well under Additional Protocol 2 in the diplomatic conference of the Additional Protocols. However, the delegates of the diplomatic conference decided to reject this proposal and to protect only a limited number of objects. Now, there are different reasons for that. The first was the fear that introducing the definition of military objective to non-international armed conflicts would implicitly acknowledge that attacks by non-state groups against the state's armed forces are legitimate acts of warfare. The second reason was what the delegates broadly referred to as sovereignty and the responsibility to maintain law and order. For example, the Canadian delegate, while referring to a related issue of the protection of objects indispensable to the survival of the civilian population, stated, and I'm quoting, that in view of the fact that both parties to a non-international armed conflict were generally fighting on their own national territory, it would perhaps be inappropriate to suggest to them that they could not deal with certain objects as they saw fit. The Canadian delegate further emphasized that, I'm quoting again, there was no question of authorizing the destruction of civilian objects, and the delegation was also in favor of reducing acts of violence, but with due regards for the internal law of states. So we can see that states' objections to the full protection of civilian objects in Additional Protocol 2 did not stem from the belief that civilian objects should not be protected, but from reluctance to legitimize attacks by non-state groups, and from concerns for the ability of states to maintain law and order. Now, despite the differences in the protection of civilian objects in international armed conflicts and non-international armed conflicts under treaty law, it is widely argued that the full customary protection of civilian objects in international armed conflict is also applicable in non-international armed conflict under customary law. Now, while it's beyond the scope of this presentation to offer a full examination of state practice and opinion jurists relating to the scope of protection of civilian objects, it's worthy to state that the argument that customary law now provides blanket prohibition on targeting civilian objects in non-international armed conflict is not based on extensive review of state practice. The ICTY, most famously in the Tadic case, advanced the argument that civilian objects are protected also under customary law in non-international armed conflict. The tribunal's analysis of state practice in the context of civilian objects referred only to 4 limited examples, which also arose prior to the adoption of Additional Protocol 2, when states clearly stated that they're not interested in protecting all civilian objects. While most other case law and scholarly work has also not provided a better analysis of state practice to support the argument that customary law now provides full protection to civilian objects in non-international armed conflict, the ICRC study of customary humanitarian law that advances the same argument is admittedly more persuasive. The study mainly relies on the inclusion of this protection in recent treaty law and various military manuals. Now, although the ICRC study usefully shows that many states do not formally distinguish between civilian objects in international armed conflict and non-international armed conflict, in general, it fails to demonstrate how states actually behaved in the situation of non-international armed conflicts when it comes to problematic civilian objects that I'm going to talk about soon. Nevertheless, it's important to emphasize that despite its problematic ground, the view that full protection of civilian objects is now part of customary law in non-international armed conflict has become the prevalent opinion among IHL scholars and jurists. Nevertheless, this view, I argue, may have undesirable results in light of states' role to maintain law and order. Now, to illustrate my point, it's useful to focus on the issue of destroying illegal property in law enforcement operation. In general, states often destroy property which is being held or used illegally in their territories in law enforcement operations, what I called illegal property. So if all civilian objects are protected in non-international armed conflict, how could a state destroy this illegal property in its territory when this property belongs to a non-state group? Although this illegal property can be different things, I wish to focus on drug farms in my presentation. So states usually destroy illegal drug farms or plantation, whether it's coca, opium, or marijuana plantations. These actions are part of states' discretion to maintain law and order in its territory and are legal under certain conditions in international human rights law. If civilian objects are not fully protected in non-international armed conflict, states could justify this practice because drug farms are not protected in Common Article 3 or Additional Protocol 2. However, if there is full protection of all civilian objects under IHL, drug farms cannot be destroyed unless they're considered military objective. So to illustrate my point, I would like to use Colombia, a state that is, of course, been engaged in an armed civil war, non-international armed conflicts against different groups, mainly FARC. Now, so for this example, let's assume that there is full protection of all civilian objects. Colombia While Colombia could destroy drug farms of criminal groups, different criminal groups, it could not destroy FARC's coca farms unless it could prove that these farms are military objectives. It has already been suggested that Colombia's policy of destroying drug farms belonging to FARC violates the customary rule of protection of civilian objects. Now, for me, it's clear that this result does not only hamper the sovereign right of states to maintain law and order, it's also unrealistic. States never intended that the law of non-international armed conflict would inhibit their sovereign right to maintain law and order. Moreover, it's questionable whether it is wise to reward the most violent group in a state by granting their property protection that other criminal groups, less violent, that are not involved in a non-international armed conflict, do not enjoy. Finally, it is doubtful whether any state is willing to accept that rebellious non-state groups should be able to maintain their drug farms or any other illegal property under the protection of civilian objects in non-international armed conflicts. Nevertheless, there are different ways to maintain that all civilian objects are protected in non-international armed conflicts and still justify the destruction of civilian objects which are used for illegal activities such as drug farms. One way is to adopt the US interpretation of military objectives. According to this interpretation, military objectives are also economic targets of the enemy that indirectly but effectively support and sustain the enemy's war fighting capabilities. So if we adopt this interpretation, we can go back to our example, Colombia, and because coca plantation constitutes a significant part of FARC's income, we can say that Colombia can target these plantations. However, the US interpretation of military objective is considered too wide because it can transform the whole economy of a given state to a military objective, and it's rejected by various scholars. But even if we adopt the US interpretation of military objectives, it still wouldn't provide for the destruction of illegal drug farms in cases where they only constitute a negligible part of the income of a non-state group, or when the income from these farms supports other activities of the non-state group, such as social activities or educational activities. A different way to deal with the issue of destruction of drug farms is to argue that it's legal because it's a legal operation under human rights law. Since it's accepted that states can still conduct law enforcement operations despite an ongoing armed conflict, provided that these operations have no nexus to the armed conflict, the main question is how we examine this nexus. The requirement of nexus has different meanings based on its purposes. The ICRC, for example, in its interpretive guide for direct participation in hostilities, has used the requirement of nexus in a narrow way as a precondition for qualifying an act as direct participation in hostilities. So even if we adopt this narrow interpretation of requirement and argue that law enforcement operations have no nexus to the armed conflict, even when the state is destroying drug farms that belongs to the non-state groups, because these operations are not specifically designed to directly cause the required threshold of harm in support of a party to the conflict and to the detriment of another, but are generally designed to maintain law and order, we still have to acknowledge different normative difficulties with this proposition. In Colombia, for example, where FARC holds a large share of drug farms, law enforcement operations can cause direct damage to FARC as a party to the armed conflict. Arguing whether these operations were specifically designed to cause damage to FARC as a party to the conflict or simply as a drug producer may prove to be problematic. And finally, we do want to avoid a situation where the concept of nexus allows the state to choose between applying humanitarian law and human rights law according to its own convenience. States should not be able to invoke the concept of a law enforcement operation as a pretext for choosing which sets of law to apply. This would undermine the basic idea that humanitarian law is to apply whenever there is an armed conflict which reflects a factual situation of hostilities and is not contingent on any formal acceptance by states. Another way of dealing with the issue of destroying drug farms in a non-international armed conflict is to focus on the relation between humanitarian law and human rights law. Although opinions diverge on the exact relations between these two branches of law, It's usually argued that during armed conflicts, human rights law applies as lex generalis, while humanitarian law applies as lex specialis. Nevertheless, it has been suggested that human rights law should apply as lex specialis in non-international armed conflicts in various aspects, such as detention and to some extent targeting. Thus, it could be argued that in non-international armed conflict, the targeting of civilian objects, which are used for criminal activities under domestic law, should be evaluated under international human rights law as lex specialis. Although this argument also has theoretical problems, it at least provides some framework under which illegal civilian objects could be destroyed. Now, the main point I wish to underline here is that accepting that states can and should be able to destroy illegal property which belongs to the opposing non-state group in non-international armed conflict, even if it's through the framework of human rights law as lex specialis, is tantamount to admitting that civilian objects in international armed conflicts and non-international armed conflicts do not enjoy similar protection. In international armed conflict, even if a state that is a party to the conflict has drug farms, the opposing state has no authority to destroy these farms unless there are military objectives. The differences in protection stem from the differences between these two types of armed conflict. Because in non-international armed conflicts, the actors are not only different, but usually the territorial state is trying not only to win the armed conflict, is also trying to maintain law and order in general. So the law, if it aspires to be realistic and respected, must reflect the differences between these two types of armed conflict. So just to conclude my thoughts on this topic, the development of customary law and the protection of civilian objects in terms of lex ferenda is of course positive. It could hardly be disputed that schools, living houses, and other civilian objects should be protected even if they do not qualify as specific object protected under Additional Protocol 2. Nevertheless, granting protection to civilian objects in non-international armed conflicts may prevent, well, full protection that is equal to the protection that these objects enjoy in international armed conflicts, may prevent states from destroying illegal property in their jurisdiction and in accordance with their domestic law and human rights law. Such a result would not only hamper states' sovereign right to maintain law and order and most likely be condemned as unrealistic, it would also harm the legitimate expectations of individuals who expect their states to provide them with safe environments which respect the rule of law. Thus, it is clear that the law regarding the protection of civilian objects in non-international armed conflict should accommodate these differences and do not provide blanket prohibition on targeting all civilian objects. And this point reminds us again that the distinction between international armed conflict and non-international armed conflict is not just an outdated distinction based on state self-interest, but is actually built on the understanding that there are inherent differences between hostilities in non-international armed conflict and in international armed conflict. Thank you.
Thank you very much. We have now reached the fourth and final presentation for this session, which will be co-delivered by Dr. Ruvi Ziegler and Mr. Lawrence Hill Cawthorne. While the technical aspects of the presentation are being launched, I will I hope very precisely. I will briefly introduce the two speakers. So Dr. Ziegler is a lecturer in law at the University of Reading in the UK and the editor-in-chief of a working paper series on refugee law, which is also associated with the Institute for Advanced Legal Studies in London. He's also a researcher at the Israel Democracy Institute. He was a visiting researcher at Harvard and a public international law tutor at Oxford. He is going to be a visiting lecturer this next year here at Hebrew U. He has served as a legal advisor for the IDF in the West Bank. He has degrees in law from Haifa University, both a first degree in law and a BA in economics. He has a second degree in law from Hebrew University, and he has 3 degrees, including a DPhil from Oxford. Well, that's the trend. Yeah, I feel very small suddenly. Dr. Ziegler will co-present his work together with Lawrence Hill Cawthorne. He's also a lecturer at law at Reading, and a final year DPhil at Oxford. Mr. Hill Cawthorne has previously held a graduate teaching assistant position at Oxford. He was a research fellow at the Library of Congress in Washington, D.C., and also had a stipendiary lecturer status at the Merton College, also in Oxford. And while Dr. Ziegler specializes both in IHL and in immigration and refugee law, Mr. Hill Cawthorne specializes in public international law, international criminal law, human rights law, and IHL. The topic of this final presentation is again non-international armed conflicts, the question of military objective in non-international armed conflicts, incorporating post-conflict considerations.
Where was he?
Strong on policy.
Okay, well, it's very nice to be here. I was here last year as well, and actually during my my presentation, actually this sign fell down whilst I was trying to present, so it was a slight distraction. I like to think it fell down though because what I was saying was so profound and earth-shattering that it literally shook the building. That's probably not the case though. So actually, mine and Ruvi's presentation follows on nicely from Noam's. We're also questioning this sort of extension of the rules of IHL traditionally applicable in international armed conflicts to their non-international counterparts. Maybe I should just move this a little. So just as a sort of introduction, I'm going to sort of outline the general thesis, and Ruvi will then discuss a few more specific aspects of the argument we're making. Just as a little context, I think Noam probably helpfully provided some of this, but just as a quick overview, we all now know that non-international armed conflicts are by far the most common. That's represented quite an important shift in the typology of armed conflict since 1945. And of course, the problem that has been faced since then is that most of the rules of IHL were designed for interstate conflicts. The traditional way in which this has been addressed, the way in which the law of non-international armed conflict has been developed, has been to draw on the rules traditionally applicable in international armed conflicts. Ironically, this was sort of partly a result of the fact that this was seen as the most effective way of humanizing non-international armed conflicts, and now we've almost seen a kind of flip on this. People are now sort of saying, actually, no, this isn't the most effective way of humanizing non-international conflicts. And this trend is also true for the definition of military objective. So whilst Noam was speaking about the definition of civilian objects and the protection of civilian objects in non-international armed conflicts, we're focusing on the kind of mirror image of that, the idea of military objectives. And again, the trend has been to draw on that definition in Article 52 of the first additional protocol and apply it, mutatis mutandis, in non-international armed conflicts. And this is what we are taking issue with. Now I'm going to press this button, and it should go on to the next slide. Good. I'm not entirely sure of the order. Okay, here we go. So the criticism we're making is that Article 52 of the first additional protocol fails to take sufficient account of certain unique characteristics of non-international armed conflicts, which are not factored into that definition simply because it was designed for international armed conflicts, where these specific characteristics don't exist. Specifically, the argument we're making is that non-international armed conflicts, because of their internal nature, because of the fact that they're confined to a single state, and because of the fact that they're between members of the same political community, they tend to often be arguably more destructive, both physically and socially, than their international counterparts. And this leads to quite serious post-conflict issues arising, including post-conflict reconstruction and the need to ensure that the specific state is governable and can essentially pick up again. We argue that these post-conflict considerations should be factored into any definition that might be developed of military objectives in non-international armed conflicts, and that it should be part of this in bello assessment. Now, the Article 52 definition of military objective doesn't allow for this to be taken account of, and we've just quoted on here the relevant sections of that definition. Essentially, the main point is that the definition in Article 52 is very temporally specific. It talks about in the circumstances ruling at the time. Now, of course, this is sort of traditionally invoked as a kind of protective mechanism. We say it has to be in the circumstances ruling at the time so as to try and avoid much broader notions of military objective being included. Now, of course, it hasn't avoided that. There's, for example, the argument that's been raised a lot that this includes sort of objects that contribute to the war-sustaining effort more generally. This sort of notion of in the circumstances ruling at the time is invoked as a way to kind of counter that. It's to make the definition of military objective more protective. Our argument is that it also, though, in non-international conflicts, has a negative side effect, which actually prohibits the rule being more protective. And that is that because it's temporally specific, because it's only looking at the circumstances ruling at the time, it's not really allowing for incorporation of the kinds of post-conflict considerations, the need to consider post-conflict reconstruction in that original in bello assessment of what constitutes a legitimate military target. So I just want to note a couple of points regarding the scope of our argument. The first one is that the argument is restricted to what we might think of as non-international armed conflict stricto sensu. In other words, we're not dealing with this notion of, so-called transnational armed conflicts that may or may not constitute A, armed conflicts, and B, non-international armed conflicts. That's not to say, though, that we're not also considering the kinds of non-international armed conflicts that we've seen, for example, in Afghanistan and Iraq. In there, we are still focusing on a specific single territory in which an armed conflict takes place, and it still involves the government of that specific territory. So that still falls within our scope. The other point we're making, which of course is always a wonderful defense that you can leap to, is that we're making the argument de lege ferenda. We're not suggesting that these kinds of post-conflict considerations currently exist in the law. In fact, we're not making any comment as to what the current definition of military objective in non-international armed conflicts is. All I've said is that in practice, the definition in Article 52 has been drawn on. That's been the case in the ICTY, it was the case in the ICRC's customary law study. So it's just about these arguments de lege ferenda. But that said, we are drawing on more generally established principles in international law to make the argument. As you can see, it's there as well. Okay, so in terms of the structure of the remainder of the presentation, I'm just going to deal with the first 2 points on here. First of all, the idea that this obligation to consider post-conflict reconstruction in the definition of military objective applies to all the parties to a non-international armed conflict. And then I'm just going to talk a little more about state responsibility and how that might impact the assessment here. Ruvi is then going to talk about some more specific issues that we can draw on. First of all, the rationales underlying derogations in human rights law offers kind of an interesting analogy that we can look to. The requirement of protecting your own territory, and then he's going to finally sort of finish off with some practical implications and considering the degree to which this should be incorporated as a legal obligation or whether it should just be about policy. So in terms of the application to all the parties to the non-international armed conflict, essentially we're arguing that this should be the case, that if we incorporate post-conflict considerations into the in-bello assessment of what is a military objective, then this should fall on both the state and non-state parties to a non-international conflict, or indeed just the non-state parties if that kind of non-international armed conflict is at play. This kind of rests on two propositions. First of all, we know that all IHL rules bind all parties to armed conflicts. It's one of the sort of distinguishing features of IHL. It binds all parties to an armed conflict, regardless of their status, regardless of the ad bellum issues. So that's the first point, and this is also why we think that this in bello assessment of military objectives should be binding both on the non-state party and the state. But in addition, non-international armed conflicts share a peculiar feature, and that is that the outcome of the conflict is indeterminate. We don't know how it's going to end. We don't know which parties are going to end up in control of the territory, whether they'll share control, whether one will win over the other, so to speak. And because of this, also, we think that it should be binding on the non-state parties to the armed conflict. And actually, this is quite an established principle in international law. In the ILC Articles on State Responsibility, Article 10 notes that violations committed by an insurrectional movement during an insurgency will be considered violations of the state should that insurrectional movement become the representative of the state in the future. In other words, what happens now, because of the indeterminacy of non-international armed conflicts, should affect the rules that apply. Okay, I'm just going to finish off then with a short discussion on state responsibility here, and then I'll hand it over to Ruvi. So the first point is that we all know that the primary responsibility for a territory and for its inhabitants rests with states. I think that's a pretty established proposition in international law. We also know that sovereignty, and when we say state sovereignty, state responsibility, it comprises not only the right to do certain things, but it also comprises responsibilities towards the population, towards a territory. This is kind of at the heart of this new movement that is sometimes sort of coined a responsibility to protect, or R2P. The point that we're making is that in non-international armed conflicts, the state is targeting its own territory and its the inhabitants of that territory, over which it has primary responsibility to protect against grave abuses. And the problem with the Article 52 definition of military objective is that this isn't factored in. It doesn't recognize this for the simple reason that in an international armed conflict, that's not the case. States aren't targeting their own territory, their own inhabitants. They're targeting another state's territory, another state's inhabitants. And for this reason, we argue that the two situations aren't comparable and that the Article 52 definition shouldn't apply in non-international conflicts. Instead, we need a definition that incorporates this kind of post-conflict considerations, the fact that at some point in the future, the state is going to have to be governable. And if both sides are targeting the same territory and the same population, that poses a serious problem for that. I'm going to now hand it over to Ruvi just to talk a little more about some sort of specific points in our argument.
Yes. Thanks, Lawrence, and thanks very much, everyone, for bearing with us in this double act. So really follows up directly from Lawrence's last point is our analysis by analogy, right, of the question of derogations. And it is by analogy because we're not taking a view on the interrelations between IHL and human rights law in situations of either international or non-international armed conflict. But we are arguing that some rationales that apply in human rights law are actually very much relevant to our discussion of the responsibilities and the issues of attacks in military objectives. So the first point to note about derogations is, right, human rights law acknowledges that states in certain situations have to forgo some of their protection obligations, right? So the language of Article 5.1 of the ECHR, and similarly of Article 4 of, Article 15 of the ECHR, Article 4 of the ICCPR talks about the exigencies, right, that arise in the time of public emergency which threatens the life of the nation, right? And so in that sort of situation, the state steps back from some of its protection responsibilities to maintain the law and order that Noam was actually mentioning. But crucially, right, this can only be done to the extent that is required by the exigencies of the situation, right? And so it is exceptional and it's temporary, right? And so what does that mean in practice? It means that the ultimate aim of derogation, right, from the state's point of view, must be the resumption of full rights protection after derogation has ceased to be necessary. So if we look at the language of the Human Rights Committee's comment on the question of states of emergency, right, it says that the restoration of a state of normalcy where full respect for the covenant can again be secured must be the predominant objective of a state party derogating from the covenant, right? And so if we assume that you're derogating in order to enable yourself as a state to resume protection obligation, and if we assume, as Lawrence has said already, that we don't know which of the sides to the conflict will be the state at the end of the conflict, then we suggest that future protection and eventual normalcy should be borne in mind during a non-international armed conflict. If you're taking a step, whichever side of the conflict you're on, that would then hinder the possibility of you governing the territory properly and ensuring full protection for all its population after the conflict, you're actually, rationally speaking, biting your nose to hurt your face, right? You are being effectively a bit masochistic, and we suggest that follows in the rest of the analysis as well, right? And it follows when we think about the rationale of international armed conflicts and why certain things don't appear there, and we believe don't appear there because it's a different type of conflict than a non-international armed conflict. And the first is really the very basic premise that if you read the protocol, it doesn't talk about what states need to be doing to protect their own military objectives, right? The assumption is that they'll do it anyway. So the protocol talks about what they need to do to protect, what they need to do in order not to harm so much civilian objects on the other side's territory, right? But in an international armed conflict, that is the case. You are attacking objective. If you manage to succeed, if you manage to gain that effective military advantage, what you're doing is you're harming the other side and you're not harming yourself, right? And you're not harming your own post-conflict reconstruction. Generally speaking, right? We'll leave occupation and other situations, exceptional situations, notwithstanding. Now, in a non-international armed conflict, in the context that Lawrence was setting out, right, we're talking about the same territory, and so if you, as one of the parties to the conflict, manages to be very successful in destroying some other party's objective, what you're actually doing, in the end, right, is you're making it more difficult for yourself, should you win that conflict, to be able to govern that territory effectively, right? It's a different frame of mind. It doesn't appear in Article 52 because it shouldn't have appeared necessarily in Article 52. That is our argument, right? And so we suggest this follows with a few practical implications. The first, and this sort of feeds back into Robin's discussion or suggestions yesterday in the concept perhaps of international armed conflict, but we suggest this is even more prescient when we're talking about non-international armed conflict. The first is really the targetability of dual-use objects. Now, one could say that in a modern state, actually many objects, and certainly when we're thinking it within the context of non-international armed conflict, effectively, very few things will not be a dual-use object, right? The roads will be used by the military or by the non-state actors and by civilians, government buildings, etc. And so in the day after the conflict, right, all of these will have to be put back to use, right? And so if we destroy them, whichever side of the conflict we're on, we're actually making this more difficult to govern in the day after, right? And we should assume, right, that the party who's, say, challenging the government, who's an insurrection movement, would actually want to govern this territory the day after, right? Otherwise, it's not entirely clear why they're doing it. And the same applies when we follow from Robin's discussion of the least restrictive means approach to the framework, which really doesn't have a preference built into it, right? The neutralization, capture, or destruction. So we would argue that the lege ferenda in a non-international armed conflict, effectively, in all cases, if you are able just to neutralize and not destroy, you should just neutralize and not destroy the object. And then thirdly, we say that we're looking at a state, we're looking at non-international armed conflict within that state still may very well have other threats emanating from outside that state that are not related to the two parties functioning, right? And those have to be taken into account as well. And we can think about countries like Syria or the DRC, right? And in these sorts of situations, if both sides are very successful at wearing each other out, at destroying each other's objectives very successfully, in the end, in the post-conflict day, that state as a unit will be less viable to defend itself against external threats. And that's something that all parties to the conflict, out of their joint responsibility, should be taking into account as well, right? So one could ask, finally, right, why should we not, if this is all intuitive and sensible, why should we not just leave it as a matter of policy, right? And indeed, political calculi may lead some states to adopt this policy. Indeed, some states have adopted it in perhaps internationalized armed conflicts, or non-internationalized armed conflicts that turn into non-international, depending how you want to consider Afghanistan and other instances, right? Hearts and minds strategies and otherwise. And there may be instances where policy would suffice. However, we think, and this is some of these points are general about policy, but one may be specific about non-international armed conflict. The policy has shortcomings. And the first is, of course, it's adopted unilaterally. It's not a treaty, and it reflects positions of particular policymakers at particular points in time. And we heard yesterday, we had a panel where people were disputing the vagueness of an existing definition, right? And when you have a treaty definition, it will still be open to contestation and deliberation. That's the nature of legal framework. And nonetheless, that is still something that is worked out between different parties and reaches some degree of multilateral cooperation and some degree of consistency. It doesn't mean that when you've got a treaty, it always applies consistently. When you've got policy, you're almost guaranteed it's not going to be applied consistently, because there are political and other considerations that fall into place, and there is no obligation necessary to apply policy consistently. And indeed, this is particularly prescient, as I say, in the context of non-international armed conflicts, because of some of the consideration even that Noam was mentioning a few minutes ago about the need for the state not to feel as if this is an equal match between itself and these horrendous insurrectional movements, and vice versa, right? The questions of legitimacy to both sides. The idea that you're thinking about post-conflict considerations, that you are framing this in a reconciliatory framework whilst you're still going on fighting that other side, bleeding to death, is not terribly too likely. So the discourse, in the absence of a framework that is legally binding, is actually less likely to be steered in the direction of thinking about these post-conflict considerations, which we argue should actually be borne in mind during the armed conflict. Thanks very much.
Okay, so we have completed the 4 presentations. I wanted to congratulate the speakers for the contents of the presentations, but also for keeping it within time, which is great and quite exceptional in these events. So we have a good half an hour for discussion, and Dave Kretschmer wants to ask the first question.
Okay, I want to relate to what Noam Zamir said. And I agree with you entirely that we have to maintain the distinction between international and non-international armed conflicts. They are not the same thing, especially when you're talking, as you said, of only internal armed conflicts. But I'm wondering about the use that you make of the nexus to the armed conflict. Because what typifies non-international armed conflicts is the state has this dual role. On the one hand, it has the protective power under international human rights law, and yet it's a party to an armed conflict. As I have always understood it, you use the nexus idea in order to allow the state to do certain things under the law of armed conflict that it's normally not allowed to do, and it would have to show that it has a nexus. to the armed conflict. Now you're turning it on its head. And what you're saying is that you're going to deny the state the power to do something which is allowed to do under its normal law because it has a nexus to the armed conflict. I don't think that is the correct question. I think that the real distinction that has to be made is conduct of hostilities on the one hand, and that has to be fairly confined when you're talking about non-international armed conflicts, and your law enforcement capacity. And I don't think the fact that you're carrying out hostilities in any way undermines your law enforcement capacity.
Noam, why don't you respond? Let's ping pong a little bit and then we'll collect.
Sure. Well, thank you for your question. I use the nexus as I understood it because, well, this is the way also Colombia and all the ICRC, and as you're right, usually it's used to show that the state can do more things to use humanitarian law. But when I started thinking about civilian objects, and specifically about the example of drug farms, suddenly it became clear that humanitarian law, in that sense, restricts the power or the authority of states to do something. Now you can say, and this maybe logically to us, especially people who are not practicing law or humanitarian law, they would say, this is a clear law enforcement operation. But I'm a bit worried about this idea that this is just a clear law enforcement operation. And we don't give it a very legal platform because, again, we're talking about something that is the hardcore of IHL, civilian objects. If states would use the idea of pretext of this is just a law enforcement in general to evade actually the protection of humanitarian law, we will reach a problem. So in general, for example, in Colombia, it wasn't even an issue so far as I know, and I asked some of my Colombian friends in court, but it could very well be an issue. I mean, a case could be argued that precisely because it's an armed conflict, precisely because now we're not talking about the normal place that the states can use its power to do law enforcement in general. This is part of the property of the opposing non-state group. It's not just a normal criminal group, and therefore the state cannot destroy the drug farms. I think that both of us maybe agree that this is not a desirable result, but it may well be this result, and I already encountered these arguments that the real issue that we need to focus is whether drug farms or any legal property is actually a military objective. And I, as I said, think that that would not only harm the specific cases of law enforcement, but it will also harm in the end IHL because we try to broaden the definition too much. Military objective to deal with a specific issue.
Okay, thank you. Yeah.
University of Exeter. I have actually two questions for Ruby and Lawrence. We may decide how to divide them up, and then one for Noam. So I understand that you have defined your non-international armed conflicts to those that are only limited to the territory of one state. But what do you make of situations of wars of secession? Do the considerations that you discuss apply to those conflicts where at least one of the parties, or arguably several of the parties, if you think about the situation in Yugoslavia in the 90s, do not have the interests of the state as it was in the beginning of the conflict at heart? So that's question number one. And then number two, and that's I think the real elephant in the room, is you're proposing that this is, a delegate ferenda argument. So how do you then turn it from delegate ferenda to a lex lata consideration? So how would this become lex lata? Do you foresee, Ruby has mentioned the treaty, do you foresee a treaty that would somehow amend the second additional protocol? And is this realistic, such a proposal that you are making? So those are two questions for you, gentlemen. And then for Noam, I understand that your argument is that civilian objects in non-international armed conflicts would not be subject to comprehensive protection as they are in international armed conflicts. But could we have a look at it, through the lens of overlap of international humanitarian law and international human rights law, and conclude that in IHL the protection is indeed different? Sorry, in IHL the protection indeed has become comprehensive in non-international armed conflicts as well, but then international human rights law derogates from these protections by applying the considerations that are inherent in international human rights law. And would that strengthen your argument, or do you have a counter-argument to that question?
Okay, let's try. We have many people who want to ask questions, so I will revert to the floor, but please keep your answers short, and then I'm going to collect a few questions. So let's start with the two of you.
Okay, well, I'll just make a few points. I think, so Cuba, the first point on secession, this is actually something that we were talking about yesterday. I think the first point, though, is that it's true that factually speaking, in certain circumstances, a non-state group may want to secede from an established state. But our starting point generally in international law is that simply isn't allowed. International law operates according to the status quo of the current state system. So that's kind of at the heart of, like uti possidetis and self-determination. You can't secede from a state. The assumption is that the state will continue. Well, you're shaking your head there. I think that's probably one of the most established principles. It came out of the Latin American decolonization and then the African decolonization. So that would be my starting point. That is kind of the default position in public international law generally. The second point, I think, is that although it's true that a non-state group may want to secede, it's also true that the non-state group may well control territory, the kind of Tamil Tigers, KLA, these kinds of situations. But it's not so clear that you can necessarily divide up also the population along those lines in a non-international armed conflict. Just because the non-state group may wish to secede and may control territory doesn't mean that you can also divide up everything in those territories in that way. Okay, sure.
Yeah, I'll just add something quickly to this. I think the key point is the indeterminacy, and that's the point we stressed at the beginning. We don't know how the conflict will end up. We don't know, even if the Neustate Act actually controls a part of the territory. We're not sure that's necessarily the territory it's going to end up with in the conflict. We don't know where the population is going to end up, and we do know that all these parties have a joint responsibility to the population of their territory as it stands at the start of the conflict, whilst the conflict's going on. If we could predict how the conflict ends, then perhaps the point actually could stand. But the basic assumption, in addition to what Florence said, which I agree with, is that you can't, and you have to work on the assumption that you don't know.
And you want to say something on on a treaty on? Or should we take this as a rhetorical question, whether there is a?
No, I think it's a very good point. I think I don't think anyone in the room would argue that there's likely to be a diplomatic conference anytime soon in which a new IHL treaty is concluded. I think probably now our best bet is to try and incorporate things more generally as policy perspectives and guidelines. And as international law has traditionally operated, it kind of percolates through and over a very long-term process is incorporated in domestic military manuals, domestic practice. And in that way it can at some point eventually crystallize as custom. I mean, that's a bit of a cop-out answer, but that's basically it.
Well, we have one, of course, historic precedent, which is the Liber Code, which started as a policy driver in circumstances not so different from the ones that you are discussing.
I mean,
but I want to go to Noam in the interest of time.
Well, thank you, Kuba. I think that in terms of goals, both of us share the same goals. Those people probably in the room. We want more protection. We want not only the limited protection that additional protocol 2 provides, we want also ousted, etc. On the other hand, we do believe that there should be more flexibility with some specific objects. Now, your argument, as I understand correctly, is to say, well, why don't we just say, yes, IHL provides full blanket prohibition, but use human rights law to derogate. And that's not limited to non-international armed conflict, that's in general, but this is exactly my fear. Because this is exactly what, bottom line, we're all trying to say that when it comes to destruction of legal property, it will be evaluated also through human rights law. What I'm trying to keep here is the distinction that it will only be limited to situations of non-international armed conflicts, because I think it would be detrimental to IHL if at the end we would create a precedent, even if it's just at the stage of conceptual precedents, that we can derogate from humanitarian law through human rights law in all type of armed conflicts.
Right, and note that Article 4 of the ICPR, of course, has this provision about not being able to derogate from your other international obligations. So I'm not sure. So there is some loop that we would have to work out. Now I'm going to collect a few questions because this has been an interesting experiment, but not a huge success of playing ping pong. Yeah, let's start, Robin.
Okay, mine is to Noam Neuman. I think I generally agree with what you said on single structures, on the roof, ground floor, wherever you find someone. My point really was that I think we cannot take it for granted that you can always, by law, take out the entire building structure. I think the onus is on you, the military, to show that there was military necessity. If there is, for example, because you don't know where in the building they were, then I would agree with you that you can take out the entire building. So I think the conclusions are not too different. Now, the problematic scenario you described is building A, building B. There is a very important military tunnel in one of them, but you don't know which. You said what the human rights lawyer told you was problematic. I wasn't quite clear what your conclusion is, so I have difficulty in saying whether it is problematic. I'll tell you what mine is. If you have two buildings, and you know in one of them is this very, very important military tunnel, the one thing you know with 100% certainty is that one of the buildings is civilian. And if you attack something knowing it is civilian, I'm afraid that would be a war crime. And so the answer is no, you can't attack. You have to go in, check out more, but you can't assume you can attack both because you know one is civilian. You must stop.
But you don't know which one.
You don't know which one,
Right.
but you know for sure one.
So you'll have a problem with your mens rea. But let's go, Mike.
I had questions for the group on their left. I have to compliment you. It was really sophisticated stuff. I really enjoyed your presentations. Let me start with Noam Zamir. The one question I had for you, it's a simple one. Why didn't you look at the Afghanistan scenario? Because it struck me that your presentation was answering a question that is no longer a problem. It's a question that's been asked and answered. In Afghanistan, of course, there was a proposal made by the SACIR to go after Afghan drug because it was, was feeding the insurgency and so forth. The German general in charge of the operation refused to go forward because he said that's not a military objective. All the states in NATO started flailing about to determine what their position was, and eventually consensus was it was not a military objective, so it could not be attacked. But then consensus very quickly came that we could support the Afghan government, its drug eradication program, because in a NIAC, the whole premise of a NIAC is that the domestic legal regime continues to exist. So it struck me that you were making a presentation about something that states have already at least 26 states, have already kind of come to a conclusion on. So I'd just be interested in why you were not focused on Afghanistan. I thought your presentation was absolutely fascinating. Because of course post-conflict reconstruction is a big problem in NIAC. Of course it's equally a big problem in IAC if you're going to occupy. And of course the United States, we did exactly what you proposed because we knew we were going to occupy Iraq. But I guess I would have gotten there by a slightly different route, and I'm wondering if you could just comment on why you didn't go this route. Why didn't you look at the possibility of simply including this in both proportionality and precautions with regard to effect on the civilian population, and say an effect on the civilian population is the post-conflict reconstruction problem. And moreover, just as a classic IHL lawyer, if I was trying to achieve, people like Robin maybe would take the same view. If I was trying to achieve that protection, I think I would do it not through the reinterpretation of military objective, but through a special protection. You would say there is special protection for these kinds of IDs.
Okay, Nina. You through, Mike? Nina.
I still both my questions, but I will still comment. I agree. Again, Noam, Zamir, again, to me, you all the time this is a problem to use law enforcement because it might diminish ISL, but I don't see the problem. Maybe to clarify more, why don't you think you could still go ahead with carrying out things under your domestic law in law enforcement, even though there's an armed conflict and we're fighting at the same time a non-violent armed conflict? Because I'm not clear what is the problem that you see in this connection. And moving along again, why not examine this under the prism of collateral damage? And it is a good question. Inside collateral damage, what goes in? Only the direct physical evaluations of the effect on the population, the effect now, the effect in the future. But I think going down that avenue, I think you would even find state practice.
Okay, Yael.
I've got a question for Noam Zamir and for Ruby and Lawrence. For Noam, it seems to me as if we've taken the civilian immunity term, which we use which laypersons use a little too literally, perhaps. Because I'm just thinking, what if during an IAC there is a person who's a civilian and has taken people hostage, I don't know, while robbing a bank or something? It's a situation where law enforcement would allow the police to shoot to kill because there's no alternative, etc. Would you say that that person is immune because that is a civilian? I'm sure it would say law enforcement model applies here, irrespective of the fact that there's also a NIAC taking place. And I don't see, in this case, I don't see the distinct, I don't think the fact that it's a person rather than an object is the relevant answer. For Ruby and Lawrence, kind of follow up on Kumo, but let's say there's a treaty. You can get your treaty. What exactly would you put in it? You noted 4 factors that you think four issues that might be factored in. Now, use the least harmful means, for example. I can understand a provision on that, but what wording would you use for the other things which seem to be very much policy-oriented, and how would you draft them? And one side question, do you think there's absolutely no distinction whether it's the government or the non-state actors? Would the rules be exactly the same, or would they be the same rules but work differently?
Well, that's a topic for another conference, maybe Francois.
Again, it's questions for the last 3 there. First of all, no, again, I'm with all the crowd that's saying, look, this looks like straightforward law enforcement, and actually, though you don't notice it, you have this same split when you carry on enforcing your law in an IAC. You're doing it in relation to your own population, but you're carrying on doing it. I think, I take Mike's point about the example of Afghanistan, where you are assisting a state, or claim to be assisting it, in engaging in its own law enforcement. I think issues could arise where state A goes into state B and is not assisting the state, and along the way of doing whatever it wants to do against an organised armed actor, also takes out the drug farms. But again, I think that element of what it's doing would be, it's not enforcing its law, or the law of the territorial sovereign, but it's engaging in an activity, lawful or otherwise, that is not actually part of the armed conflict. Because the danger, I think, with your approach is once you start saying we have to rethink protection of civilian objects in NIACs, if you start opening the door, there's a real risk that other problems would arise. And it may be that a useful distinction could be made between AP2 NIACs and Common Article 3 ones. Because in Common Article 3 situations, usually the state doesn't acknowledge it's an armed conflict, even if the law of armed conflict applies. And in terms of treaty law, there is no Hague stuff, so there's nothing on civilian property. And you also might get some ideas, by analogy, from the old Hague 4 Convention. If the organised armed group claims to own a drug farm, isn't that state property that you're entitled to take, if it, by analogy, with an IAC? In relation to Ruby and Lawrence, again, I think that in some ways what others have been saying, that they haven't phrased it like this, you're not being ambitious enough. Your rationale clearly applies in relation to occupation. If you're making any reliance at all on the concept of responsibility to protect, in the first place, that responsibility attaches to the territorial state, but there is a communal responsibility to protect. Therefore, shouldn't it be factored into IACs? Why be so unambitious?
Okay, I'm going to revert now to the speakers. Just to, for the sake of a little bit more equilibrium, I'm going to pose 2 quick questions to Noam and Eitan here. I want to offer you, Eitan, an opportunity to respond to the initial statement made by Noam concerning what can one learn from numbers? Do numbers tell us anything about normativity? So this is one thing. And to you, Noam, Neuman, the question is, I'm wondering whether the approach, the holistic approach, taking the whole building as the object, how would that interplay with Article 57, with your precautionary obligations and the harm mitigation? Because if we accept it's a dual-use object, the question is whether by classifying the whole object as one military object, you you evade your Article 57 obligations. I would be interested to hear your thoughts on this. So let's start in the reverse order. You guys have to work harder. So you start, and we'll work our way to the right.
Okay. Well, I hope I can remember who asked the questions because I didn't do the correct thing and write down names. But so, Mike, first of all, this issue of proportionality. That was actually one thing I thought about as well, whether we could just kind of factor this into an already pretty broad test. And I think that is a good point. I think the difficulty, though, is that, you know, I think it's vital that we maintain the separation of the distinction and proportionality tests, and I think you agree with that. The question of distinction comes first. That's the first thing we have to get to. And I'm just not comfortable with the idea of shifting questions of distinction and what we consider to count as a military objective into the second stage of the test. Because essentially you're saying prima facie, you can then target this. What I want to do is try and kind of bring it into the initial stage of the test. I don't like the idea of sort of shifting, and that, I mean, this is probably where we disagree, and you also raised this proportionality issue. I thought your presentation yesterday was really interesting. I like the idea of, I think using the proportionality test in that way is very interesting, and there is potential there, but I'm still very skeptical of trying to shift the difficult questions at the second stage and basically answer them all at the first stage as saying, yes, prima facie, you can target them. In addition to that, proportionality itself has plenty of problems, you know, when, you know, 50%, 60%, 70%, all of this. Okay, Yael, the question of the treaty, how would we phrase it? What would we put in it? So first of all, it's not that I think that we simply can't adopt a treaty and so we should shift over to starting with policy. I actually don't think a treaty would be a good idea here. I'm not sure that it would be simple to phrase it, but as various people were talking, I did make an attempt. So we have the Article 52 definition. I don't think you should necessarily tinker with that, but I think you should probably have a sentence in after it, where you could say, and I'll sort of give a brief version of how we might add it in, but I actually think maybe a formula like Common Article 3 might be a good one, where you lay out a general principle and then offer an inexhaustive list of examples. So your sort of sentence added on to 52.2 could be something like, when making targeting decisions, shared responsibility to ensure future governability and protection must be factored in. This includes but isn't limited to, and then our examples of dual use, least harmful means in that question of sort of destruction over neutralization. I mean, that would be my idea. There's a problem with that as well, and you know, Common Article 3 isn't exactly a perfect provision. But it is actually quite useful, I think, to have that general principle with examples giving an idea of what you kind of mean by it. And then the final point, occupation, I'm going to leave it to repeat.
Okay. Yeah, so I'm not going to repeat the brevity and superfluousness things of Lawrence. I generally agree. I think on occupation there are two things. So one is a question begging answer, which is sort of to say, well, but there we do have a clear provision that applies because occupation is part of additional protocol 1. And so we are, as you were, not taking a view as to what the definition of a military objective is in additional protocol 2. So we're starting from scratch. It's an easier. But I think the main answer is different. The main answer is that our starting assumption when a conflict is going on is that the territory will remain as one territory and will have to be governable, and there may be caveats, as Kuba said, there may be secession. The starting point with occupation, if you've got an interstate conflict, cannot be that at the end of the conflict another territory is going to be occupied by one of the parties. It cannot be the assumption that the one state will take over the other state. So if we build that into the assumption, that is a consideration. So the regime that applies to occupation applies once hostilities cease, right? But we're trying to calculate how one targets whilst the conflict's going on. Whilst the conflict's going on, we cannot predict that there will be an occupation, as you were. And certainly we cannot assume
the Americans could predict that they would
Well,
occupy Iraq.
Well, certainly they convey the idea that they will be occupied in advance,
Right.
as a policy matter. And I think one other point I would make. I mean, I do think that if one were to go into a wording, then you could really build in a least restrictive definition, even within the framework that does exist under Article 52. You could say in order of preference, or you could. I mean, there are ways. I don't think the language, sort of the technical question of how one phrases it, should be our main point of concern now. I mean, we should. If our argument's convincing, then we still have 195 countries to convince. We'll work it out.
Thank you, Noam.
Thanks. Okay, I will answer two questions, Yael's and Nina's question together, because I think both of them basically wanted to know, or basically asked me to highlight the problem that I see here. And the problem I see here again, that it's true that normally state could destroy this object, but this is the whole point of IHL, that we have a shift here of the applicable law, and in this case, it's quite a clear example of civilian object. It's belonged to the non-state group. So under IHL, strict we're talking about international armed conflict. It would be beyond doubt that you cannot destroy it just because it's a drug farm. Now, with Yael, you asked me about the question of hostage and civilian. That's a good example. I mean, usually here the nexus is quite useful in order to analyze it, whether this person has any connection, because I thought because this hostage crisis has no connection to the armed conflict at all, so of course law enforcement would be, and you could kill him, of course, and it won't violate any point of IHL. Now, if it were IHL, you could also say that, one, for example, if the guy who is involved in this hostage crisis, the way I say it, the more problematic scenario would be if he belongs to an armed group, to the non-state group that is fighting against the state, and then we'll probably ask ourselves whether the state is obliged to use law enforcement operation to try and stop him, assuming that we can establish, of course, that this hostage crisis has no connection to the armed conflict, and it's just a guy who is trying to rob a bank. And then we'll, of course, have to argue whether you need to try and arrest him, or because he is a member of this non-state group, it doesn't matter that this specific action has no connection to the non-international armed conflict, and you can just target him. With regard to the case of Afghanistan, actually this case is what made me start thinking about this problem. So it is useful, and I refer to it in my paper, it is useful to highlight the problem. This is the first point, it's very useful. The second point, it shows that the interpretation of military objective, it is too broad, was clearly rejected. The third point, I think, it shows that states understood that even in a situation of non-international armed conflict, when the territorial state is asking the help of other states to enforce the law, they can do it. So it's very useful in showing also state practice, but it doesn't solve the theoretical problem here of how do you justify it. The fact that Afghanistan is asked is just proof, okay, so we're going back to this scenario, so it's Afghanistan, a non-territorial state trying to enforce its law. When it comes to something that in its core it's very protected, actually connection also connected to IHL. And lastly, well, there are 2 points that I thought really worth thinking more about. First is to differentiate between non-international armed conflicts via Common Article 3 and Additional Protocol 2. The main problem here, I think, that most scholars are today trying to argue at least that customary law applies without any distinction to non-international armed conflicts.
Charles Garraway and I think that state practice doesn't actually support that proposition. Some of the examples given in the ICRC customary law study were expressly related to AP2 and are used to support Common Article 3.
Yeah.
But many of the old farts disagree with both Colonel Garraway and Professor Hampson.
Well, as I stated, I also think that the ICRC manual interpretive went because the study of the customary international humanitarian law went a bit too far, and I stated that it's very general. But also when it comes to civilian objects, protection of civilian objects, I don't know how many people would want to state that there is a difference between armed conflicts under Common Article 3 and Additional Protocol 2. It's very useful actually to look at Hague law, and it might be useful actually establishing the argument that there is already an exception in international humanitarian law to do this. But then we'll reach a segment.
Thank you, Noam. Noam Neuman.
First, a proven question regarding the one house and two houses. First, I want to say that the aim of the presentation was not to give answers, just to ask questions, to tell you what are the dilemmas, what interpretations might be in relation to this question, and to have discussions regarding them, but not to give you a straight answer. I'm not sure there's an answer that is really 100 proof and everyone can agree about it. But regarding the first example, the one building, and within you know where which part is being used for military purposes, and you just say that if you know this, you might not be able to attack the whole house because there is no military necessity to do this. The problem with this is that an army can argue, if you ask me to attack the specific floor, that means I have to spend much more time, much more effort. I will not be able to conduct much more operation in other parts. There is a very, very crucial need in order to continue with the attack and not to start to pinpoint every time that we think about a specific place in a building. And it's very problematic to ask the IDF, you know, every army, you need to have much more information, and otherwise the attack might be an indiscriminate attack. And I think it's give incentive to armies not to have enough information. Because if you have enough intelligence, you must attack this floor. But if you don't have it, if you just know something in the building, it's better to be in this, under these conditions, because in that case, you will be able to attack everything, and there is no and I think this is a problematic thing. But still, I think there might be case to discuss it and to say if there are cases in which you might want to ask armies to be much more forward, and especially when you're talking about this kind, when you're talking about property, not about civilian lives. Civilian lives, of course, have to be dealt into account. And even about, if you think about money, sometimes you can ask armies, you know, if you want to destroy one floor, you have time, you have the weapons, it will cost you, let's assume, $1,000. We want to $100,000 because the accurate weapons is very, very expensive. If you want to attack everything, it will cost you much less. The house costs much less than this. It's better to use the less precise one and pay the money to the army because it will cost you that much less money. And it's not every time intuitive to think about this, what are the obligations. But I think it's things that you need to consider, and there's a floor for discussion. And regarding the two houses, as I say, I don't have exact answer. I think there are cases in which it will be less clear. It's very, very problematic to say you cannot attack none of them. There might be cases in which it's more clear. There might be cases in which it's much more problematic. I think it's worth discussed. I think there might be a place for review that it will be legitimate and lawful to attack, especially in the example that I gave about one compound, on about if the collateral damage or the damage to civilians is very, very low and the military need is very, very high. I think there is a flaw to consider that this attacks as lawful attacks, but I think that this issue should be discussed because it's a very, very important one, and I think it's worth discussion.
Okay, thank you, Eitan.
In principle, I presented the quantities to show that when it comes to war, the discussion on whether regarding PGM is premature. However, when it comes to cluster munition, quantities do matter. Noam mentioned that he was involved, and I'm fully aware that legal advisors were presented at every decision-making forum, like targets and sorties approval. Okay.
Only the legal ones.
Attorney General Many Mazuz, when he testified before the Winograd Committee, said that there was no such a war in which legal advisor was heavily involved. So my point is that if a state shower millions of bomblets, on built-up area in another state, and it's still considered legal, and it was approved by the legal advisor, then it means that we have a problem with the IHL, and it's good that there is a total ban.
Okay, please join me in thanking the speakers.